Peace and love. Peace and love. I am the Noble Sultan, Victor Royce Duquette. I have information from the Moorish National Republic Federal Government. The Moorish Divine National Movement of the World for the world. Northwest Mexum, Southwest Mexum, Central Mexum, adjoining islands, and Atlantis. The true and de jure natural peoples, heirs of the land. To all elected, all non-elected, and to all appointed United States Republic officials. Public servants and officers of trust, etc. Doing business as of and for the federal, state, city, and municipal governments, including their personnel, their contractors, and their other associate corporate entities doing business at North America, and to all third-party interlopers or contractors concerning their fiduciary obligations, their official oaths, and their duties enumerated in the American Constitution adopted for the governance of the United States Republic, all binding treaties, the established law of the land, and all statutory and civil law codes of the land, etc. Know all men by these publications and presents. Upon our heirship, inherited nobility, and upon our private Aboriginal Indigenous proper person status and commercial liability, I, the Sultan, Noble Victor Royce Duquette L., being duly affirmed under consanguine unity, pledge my national, political, and spiritual allegiance to our Moabite Moorish nation, being the archaic Aboriginals indigenous of Mexum, the Americas, and also upon our heirship, inherited nobility, and upon our private Aboriginal indigenous proper person status and commercial liability, all Moors for North of Mexum, Southwest of Mexum, Central Mexum, adjoining Atlantis Islands, Americana Islands, and Atlantis, and Moorish Local 7 Temple, and the Temple of the Moon and Sun. Being duly affirmed under consanguine unity, pledge our national, political, and spiritual allegiance to our Moabite Moorish nation, being the archaic Aboriginals, indigenes of Mexum, the Americas, standing squarely affirmed upon our oath of the 5 points of light: love, truth, peace, freedom, and justice. Do squarely affirm to tell the truth, the whole truth, and nothing but the truth. And having knowledge and firmly established belief upon the historical, lawful, and adjudicated facts contained herein, being competent in our own proper person to attest this affidavit, upon which I place my autograph, whereas I state, proclaim, declare the following to be true, and yes, I proclaim, and we proclaim the following to be true, correct, certain, complete, not misleading, supreme, and not intended to be presented for any misrepresented, colored, or improper use or purpose, to wit, that I, the Sultan, Noble Victor Royce Duquette L., and all Moors from, for, and on Northwest Amexem, Southwest Amexem, Central Amexem, adjoining islands and Americana Islands, all that are of our bloodline, from our bloodline, are the noble of the Almoroccan Empire. We are all the nobles of the Almoroccan Empire. That is what makes us Moorish and Moors as well. We are all in proper persona, in propria persona, in my own, in our own proper self, being Moorish American, an heir and descendant of the ancient Moabites, Moors by birthright, by freehold, by primogeniture, and by inheritance, by aboriginal and indigenous to the lands of Americas, territorium, hereditaments of my and our ancient Moabite Moorish foremothers and forefathers, to wit, the Almoroccan American continents are the lands of the Moors, being North America, South America, Central America, including the adjoining islands, Americana, El Moru, Almorac. I and we have, I and we acknowledge, I and we claim, and I and we possess, by the said inheritance and primogeniture, the freehold status thereto. I claim and possess by the said inheritance and primogeniture, and we claim and possess by the said inheritance and primogeniture, the freehold status thereto, all unalienable and substantive rights to be, to enjoy, and to act distinct in our aboriginal traditions, customs, and cultures, and determining our own political, social, and economic status of the state. I and we are turning our hearts, our allegiance, and our minds back to our ancient mothers and fathers, Moors, Mers, with cognate honor, and by divine and natural right, being Moorish Americans, the direct heirs and descendants of the ancient Moabites, we have and possess the divine and internationally recognized rights to our hereditaments and resources, and proclaim the right to determine our own social, economic, and political life and status of the state, and in harmony with international law, with such rights of claim being absent of foreign law threats, coercion, or acquiescence to a color of law, a color of office, nor to be subjected by any occupying foreign persons to any imposed frauds, nom de guerre, or color of authority, Moorish Americans, Moors, have proclaimed and possess the unalienable rights, substantive rights, and birthrights, inheritance to our ancient pedigree, traditions, and customs, and the right of claim to our Almaracan attributes, names, and nationality is substantiated by and supported by nature's law, by divine law, by primogeniture, and by the recognized laws of the nations of the earth, international, being the true ancient aboriginal, indigenes, and heirs of the land of Mexum, America, the North Gate, being the geographical heartland, Maghreb, of the land of Mexum, America, the North Gate, being the heartland, the geographical heartland, Maghreb of the Moroccan Empire. Moors, Moors, are the de jure and rightful freeholders by birthright, by inheritance, and by primogeniture status, and have by those inherited rights descendable claims. Note to all comers that we, heirs of the land, possess the secured rights to travel upon the lands of our ancient foremothers and forefathers, upon the public roadways, upon the byways, and upon the highways of our continental United States, relating to the organic land, and absent of the genocidal fraud, base extortion, tributes, and human trafficking imposed by foreign colored inquisitionists or by their corporation. Imposed excise taxation constructs invented by the racketeering anti-constitutional foreign states legislators constructed under color and style to abridge and to steal substantive rights belonging to the natural peoples. These substantive rights are supported by royal law, Moorish law, Muslim law, the law of the Great Peace, the law of nature, divine law, nature's God, the law of nations, the law of the Great Peace, the laws of nature, divine law, nature's God, laws of the nation, the free Moorish Great Seal, Zodiac Constitution, stare decisis, res judica, and bindingly affirmed by Articles 3, 4, and 6 of the American Constitution Covenant of 1774 through 1781 AD, and Treaty (1200) through 1 MC, as lawfully adopted for the United States Republic, establishing its republican form of government, as lawfully adopted for the United States Republic, establishing its republic form of government. The said American Constitution established the people's supreme law of the land, standing upon the principles of moral government to secure the rights of the people, and to keep limited government operatives bound and in check by official oath and by official bond. Let it be known down from the ancient ones, our primogenitures, came the Aladao and Samnite principles which establish the supreme law of the land. Again, the said American Constitution established the people's supreme law of the land, standing upon the principles of moral government to secure the rights of the people and to keep limited government operatives bound and in check by official oath and by official bond. Let it be known that down from the ancient ones, our primogenitors, came the Aladao and Samanai principles which established the supreme law of the land. Egypt, Ecupta, is the capital empire of the Dominion of Africa. The inhabitants of Africa are the descendants of the ancient Canaanites from the land of Canaan, the Moabites from the land of Moab, who received permission from the pharaohs of Egypt to settle and inhabit northwest Africa, the Moabs from the land of Moab, who received permission from the pharaohs of Egypt to settle and inhabit northwest Africa. They were the founders and are the true possessors of the present Moroccan Empire. This includes Algiers, Tunis, Tripoli, Mauritania, and the Americas, with their Canaanite, Hittite, and Amorite brethren who sojourned from the land of Canaan, seeking new homes. Their dominion and inhabitation extended from northeast and northwest Africa, across the great Atlantis, even unto the present North America, South America, and Central America, and also Mexico, and the Atlantis Islands, Americana, before the great earthquake which caused the great Atlantic Ocean. The Great Seal Pyramid is the national emblem and insignia of the Moorish nation empire of North America geographical location. The Great Pyramid, equilateral, is also the archaic symbol for the civilizations on the planet Earth. The Honorable Moors acknowledgement of our national government. Moreover, the Honorable Moors acknowledgement of our Great Seal indicates those heirs who own up to, who support, who proclaim our free national government. Moors who are not active and not passive have no place in a place where we must be active and not passive at the moment. So Moors who are active and not passive in the social civilization, culture, and custom matters involving law, order, governmental principles are hereby entreated to support this affirmation. Moors, Mers, who strive towards this end with honor are entrusted by Noble Drew Ali to help in the great humanitarian work of uplifting ourselves, our fellow man, and humanity at large. We, the conscious heirs, seek at all times to be cognizant of the civilization works, instructions, and progressive acts necessary to teach, to preserve, and to defend the nationality and birthrights of all Moorish Americans, Al-Moroccans, etc. The noble Moors, heirs apparent, are the natural members, citizens of the ancient Al-Moroccan Empire, North America, the North Gate, and are by civic and social duty bound to recognize and to support our Great Seal sovereign Moorish national federal government and consanguine nation of the natural people. In our relation with others, we command the enforcement of our Al-Moroccan Constitution. Thus, such organized communications and orders are referred to as the Great Seal National Association of Moorish Affairs. The Free Moorish Nation, inclusive of all the Aboriginal indigenous tribes and provinces of the natural people, etc., are the rightful bearers of the attributes, names, and noble titles Ali, El, Bey, Dey, and Al. The free Moors, Mers, by freehold inheritance, retain all substantive rights and immunities, enjoy the exercising of all substantive rights, and operate upon consummated right law and Samanai principles, having pre-existing vested constitution and treaty, secure rights and immunities from foreign corporate taxation and from foreign criminal and civil jurisdiction by and of the colonial United States Rights Republic USA, private corporation and persons, pursuant to, but not limited to, divine right, the United States Republic Supreme Court, international law, and the acts of state, to wit. Every sovereign state, people, is bound to respect the independence of every other sovereign state, people, and the courts of one country, people, will not sit in judgment on the acts of the government of another, done within the same or its own territory. The present Union States municipal and civil laws and codes imposed upon the land are private, law incorporated unit of self-government established by the political powers of the General Assembly of each state of the Union, limited and bound by Article 4 and initiated at Philadelphia, Pennsylvania, North America, in the year 1854. It governs only the rights and conducts of the alleged white people, Christians, and Jews of the 1863 Union States Rights Republic. Under the Magna Carta, the Great Charter, the Knights of Columbus Code, and the Ku Klux Klan Oath, forever the said Union States Rights Republic denies citizenship in the United States Republic, all capitals, U.S.A. to the heir descendants of the Moorish nation in the Western Hemisphere, who have been erroneously referred to, branded, and mislabeled as Negroes, blacks, coloreds, African Americans, Latinos, Haitians, Mexicans, Brazilians, etc., etc. In addition to the Supreme Court of the United States in the landmark case of Dred Scott versus Sanford, 60 U.S. 19 Howard 393, 1857, held that Negroes, whether held to slavery or free, were not intended to be included in the category ever of citizen subjects of the United States Rights Republic. Resultantly, the true indigenous nobles of the Almoroccan Empire, free Moors, bear the attributes, appellations, noble titles, Ali, El, Bey, Dey, and Al, are excluded from the Union States Rights Republic, capital U, capital S, capital A, jurisdiction. The true nobles of the Almoroccan Empire are sovereign, private, and self-governed by right law, principles, and customs, and only obligated to the free Moorish Zodiac Constitution, Circle 7, archaically established by our ancient foremothers and forefathers. Such extended allegiance and obligation includes the Great Seal and the high principles and moral standards embodied in the Moorish national flag standard. Not the red, white, and blue star-spangled banner. It is only a banner of commerce. Our flag is red. If you include the protectorate, it's with the 5-point green star. We are removing the protectorate, returning back to the red flag. Love, truth, peace, freedom, and justice. The true Almoroccan noble indigenes of the land maintain a constitutional and lawful non-obligatory status. Once again, in more detail, the true Almoroccan noble indigenes of the land maintain the constitutional and lawful non-obligatory tax status and position relative to all foreign entity taxation indigenes not taxed, and maintain a non-obligatory respect for the United States Rights Republic, capital U dot, capital S dot, capital A dot, its members, its laws, its ordinance, its codes, its customs, and its traditions pursuant to the Free Moorish Zodiac Constitution, Articles 4 and 6, the Treaty of Peace and Friendship between the United States and Morocco, 1786 through 1787, superseded by the Treaty of 1836. Resolution 75. Journals of the House of Representatives. The also adopted for the United States, April 17, 1933, AD. Moorish American Society, Moorish American Society of Philadelphia, and the use of their names. Reaffirmations have been made via the United States nations, moreover the United Nations. Once again, Journals of the House of Representatives adopted for the United States, April 17, 1933, the Moorish American Society of Philadelphia, and the use of their names. Reaffirmations have been made via the United Nations Declaration of the Rights of the Child. General Assembly Resolution 1386. 14. UN GAOR number 16. At 19, UN document A/4354, 1959. United Nations Universal Declaration on Human Rights, Article 15. General Assembly Resolution 217 A 3 of 10, December 1948 AD. Executive Order 1310-7, United States Republic, North America. The implementation of human rights treaties. The National Constitution for the Continental United States, Article 3, Section 2, Amendment 5, Liberty Clause. Amendment 11, Reservation of the Rights of the People. The United States Department of Justice Moorish Credentials. Free Moorish Zodiac Constitution. Truth A1 Classified. United States Copyright Certificate Number AA222141, Clock of Destiny. The Moorish Nationality and Identification Card. Moorish Holy Temple of Science, Moorish Science Temple of America Identification Cards, etc. Furthermore, I assert my and our full birthrights, sovereignty and substantive rights, and our right of claim to all hereditaments. Being a sun-dried free Moor, and a natural being distinguished from all and any spurious contracts. Once again, being a sun-dried free Moor, and a natural being distinguished from all and any spurious contracts created by the foreigners or by their agencies pursuant to Moabite Moorish pedigree, the Free Moorish Zodiac Constitution, the Great Seal of the Moorish Nation ab Antiqua, the Treaty of Peace and Friendship, 1786 through 1787, 1836, the Sundry Free Moorish Act of 1790, the 1781 Organic United States Constitution, the Moorish Federal Financiers Act, Union States Army, 1861-1863, the 1854 Roman Catholic Magna Carta, the Knights of Columbus Code, the Ku Klux Klan Oath, the United Nations Charter, Article 55C, the Rights of Indigenous People, Part 1, Articles 1, 2, 3, 4, 5. Part 2, Article 6, the United States Supreme Court Acts of State, the Foreign Sovereign Immunities Act, 28 U.S.C. 1601, etc., the Convention on International Road Traffic, Day 19, September 1949, the World Court Decision, The Hague, Netherlands, Day 21, January 1958 AD, which is 1378 MC, in reference to the rights of the natural peoples and our substantive rights, etc. The following are pertinent and established Supreme Court decisions, stare decisis, and res judica, to wit: 1. The right to travel, the right to mode of conveyance, the right to locomotion are all absolute rights, and the people cannot make void the exercise of rights. State versus Armstead, 60 S 778, 779, and 781. 2. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and natural beings cannot be deprived of. Chicago Motor Coach versus Chicago 337, Illinois 200, 109, NE 22, ALR Ligier versus Chicago 139, Illinois 46, 28, HE 934, Boone versus Clark 214, SW 607, 25 AM, Juror 1st, Highway Section 163. Three, the rights to park or travel is part of the liberty of which the natural pagan. One moment. I'm going to another page so I can get this a better. You see, has a. I'm gonna do that sentence over. Here we go. The rights to park or travel is upon the liberty of which the natural people, citizen, cannot be deprived without due process of law. Under the Fifth Amendment of the United States Constitution, Kent versus Duels, 357, U.S. 116, 125. 4. The right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right which he or she has under the right to life, liberty, and the pursuit of happiness. Thompson versus Smith, 154 SE 579. 5. The state police power extends only to immediate threats to public safety, health, welfare, etc. Michigan versus Duke, 266. U.S. 476. Lead at 449. Which driving and speeding are not. California versus Farley Head. RPT 8920. CR 3rd 1032. 1971. Once again, 5. The state police powers extends only to immediate threats to public safety, health, and welfare. Michigan versus Duke, 266, U.S. 476, LED at 449. Which driving and speeding are not. California versus Farley, CED, RPT 8920, CA 3rd 1032, 1971. Six. The state is prohibited from violating substantive rights. Owens versus City, 445, U.S. 662, 1980, and it cannot do by any one power. Example, police power. That which is, for example, prohibited expressly to any other such power. Example, taxation, eminent domain. As a matter of law, U.S. and Utah versus Daniels, 22, page 159. Nor indirectly that which is prohibited to it directly. Fairbanks, U.S. 181, U.S. 183, 2. Fairbanks versus U.S. 181, U.S. 283, 294, and 300. Again, 6. The state is prohibited from violating substantive rights. Owens versus City, 445, U.S. 662, 1980. And it cannot do by one power, example, police power, that which is, for example, prohibited expressly to any other such power, example, taxation, eminent domain, as a matter of law. U.S. and UT versus Daniels, 22, page 159. Nor indirectly that which is prohibited to it directly. Fairbanks versus U.S. 181, U.S. 283, 294, 300. 7. Traveling in an automobile on the public roads was not a threat to the public safety or health and constituted no hazard to the public, and such a traveler owed no other duty to public, example, the state. He or she and his or her auto having equal right to and on roadways, highways, as horses and wagons, etc. This same right is still substantive rules, and that speeding, running stop signs, traveling without license plates or registrations are not threats to the public safety and thus are not arrestable offenses. Christie versus Elliott, 216 I 131, 74 HE 1035, LRA NS 1905 through 1910. California versus Farley, 98 CED RPT 8920, CA 3D 1032 1971. 8. Under the United States Republic constitutional system of government and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. Mugler versus Kansas, 1213, U.S. 623, 659 through 60. Again, 8. Under the United States Republic constitutional system of government and upon the individuality and intelligence of the citizen, the state does not claim to control one's conduct to others, leaving one the sole judge as to all that affects oneself. Mugler versus Kansas, 1213, U.S. 623, 659 through 660. 9. Where rights secured by a constitution are involved, there can be no rule making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, 125. 10. The claim and exercise of constitutional rights cannot be converted into a crime. Miller versus Kansas, 230 F. 2nd, 486, 489. 11. For a crime to exist, there must be an injured party. Corpus delicti. There could be no sanction or penalty imposed on one because of his constitutional right. Shear versus Cullen, 481 F 945. 12. If any tribunal court finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. Louisville versus Motley, 2111, U.S. 149, 29S, CT 42. The accuser bears the burden of proof beyond a reasonable doubt. 13. Lack of federal jurisdiction cannot be waived or overcome by agreement of parties. Griffin versus Matthews. 310 F. Supora. 341, 342, 1969. And want of jurisdiction may not be cured by consent of parties. Industrial Edition Association, VC.I.R. 323 U.S. 310, 313. Whereas, in light of the foregoing jurisprudence, stare decisis, and res judica, affirmed and declared by the Supreme Court decisions, by fact and by law, and counter to the negative and colorable social and political conditions instituted by corporate state persons of the Union State Society, there exists a blatant want of jurisdiction on the forepart of the Union States Rights Republic, capital U dot, capital S dot, capital A dot, and by its agents, personnels, contractors, and assigns. Maxims and axioms are lawfully, legally enforced under national and international law attending to these issues. And this affiant being natural being, and propria persona does not abandon any of my estate rights, do not waive any substantive rights, does not transfer power of attorney to any foreigner, and does not willingly consent to any public trial or ministerial hearing in any colorable tribunal venue or involvement with any non-Article 3 constitutional jurisdiction. The official oaths and bonds, the obligations and fiduciary duties of all accusers and proof bond claimants to national constitution and treaty law and order, the civilization principles fixed in constitution law still stands. Definition and truth still rules. Non-compliance is a federal law violation, an international law offense, and trespass. Whereas, in the light of foregoing jurisprudence, stare decisis, and res judicia, affirmed and declared by the Supreme Court decisions, by facts and by law, and counter to the negative colorable social and political conditions instituted by the corporate states persons of the Union State Society, there exists a blatant want of jurisdiction on the part of the United States Rights Republic, capital U dot, capital S dot, capital A dot, and by its agents, personnel, contracts, and assigns. Maxims and axioms are lawfully, legally enforced under national and international law attending to these issues. And all mores, natural beings, and propria persona from northwest Amexum, south Amexum, and Central Amexum, and all surrounding islands. does not abandon any of our state rights. We do not waive any substantive rights. And we do not waive any substantive rights, and it does not transfer power of attorney to any foreigner. And we do not transfer power of attorney to any foreigner. It does not, and we do not, willingly consent to any public trial or ministerial hearing in any colorable tribunal venue, or the obligations or any involvement with any non-Article 3 unconstitutional jurisdiction. And once again, because I'm rescinding one word, the maxims and axioms of our people are all lawful, legally in force under national and international law intending these issues. And this and all mores of from and part and parcel of North Amexum, South Amexum, Central Amexum, and all surrounding islands. Do not abandon any of our state rights. Do not waive any substantive rights. We do not transfer power of attorney to any foreigner. We do not willingly consent to any public trial or ministerial hearing in any colorable tribunal venue, or willingly consent to any public trial or ministering hearing or any colorable tribunal venue involvement or any form with any non-Article 3 constitutional jurisdiction. The official oaths and bonds, the obligations, and the fiduciary duties of all accusers and proof-bound claimants to national constitution and treaty law and order. The civilization principles fixed in constitution law still stands. Definition and truth still rules. Non-compliance is a federal law violation and international law offense and trespass. Whereas there is no question that a bench appearance summons, a detention, an arrest, a ticket or citation issued by a police, in brackets because he's a de facto officer, or by others against the people for traveling with no driver's license, foreign driver's license, not having current registration or mandatory insurance, etc., which carries a fine or jail time, is a penalty or sanction and is indeed converting a right into a crime, thus violating substantive rights. It is reasonable to assume that these Supreme Court judicial decisions are straight and to the point, and there is no lawful method for government to put restrictions or limitations on rights belonging to the people. Whereas, once again, There is no question that a bench appearance summons, a detention, an arrest, and a ticket or citation issued by the de facto police officer or by others against the people for traveling with no driver's license, foreign driver's license, not having current registration or mandatory insurance, etc., which carries a fine or jail time, is a penalty or sanction, and is indeed converting a right into a crime, thus violating substantive rights. It is reasonable to assume that these Supreme Court judicial decisions are straight and to the point, that there is no lawful method for government to put restrictions or limitations on rights belonging to the people. That the organic United States Republic Constitution, derived from ancient Moabite Moorish law, remains the supreme law of the land, and all treaties made or which shall be made under the authority of the United States government and under its flag of peace, pursuant to United States Code Title 4, Chapter 1, any law or colorable process which are repugnant to the Constitution or treaty shall remain forever colorable and are null and void. Marbury versus Madison. 5 U.S. 137, 140, 174, 176, 1803. Any municipal officer, officers, person, persons, personnel, employee, employees, or contractors, contractors, who violate or abridge the rights of the natural peoples or citizens are subject to suit or other tort action in their personal or official capacity, to wit. Title 18, Part 1, Chapter 13, Subsection 241 of the United States Code of Law. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or distract in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highways or on the premises of another with the intent to prevent or hinder his free exercise or enjoyment or any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. Title 18, Part 1, Chapter 13, Subsection 242 of the United States Code of Law. Whoever, under color of any law, statutes, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such persons being an alien, or by reason of his color or race, that are prescribed for the citizens, shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or for life or both, or may be sentenced to death. Again, Title 18, Part 1, Chapter 13, subsection 242 of United States Code of Law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, penalties on account of such person being an alien, or by reason of his color or race, that are prescribed for the citizens, shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or for life or both, or may be sentenced to death. Once again, that was Title 18, Part 1, Chapter 13, subsection 242 of the United States Codes of Law. Therefore, in preservation of the rights of indigenous people and the preservation of the rights of the people, in accordance to the defense of the Constitution for the United States Republic of North America and its Republican form of government, being the supreme law of the land, and primal to the contractual liabilities, oath, bond obligations, and fiduciary duties of officers of the court, federal, state, city, municipal, etc., we and I hereby demand enforcement of the de jure laws of the United States and all treaties made under the authority of the United States in accordance with Article 6 of the Constitution, the Bill of Rights, the Declaration of Rights of the Child, the rights of indigenous people, the Universal Declaration of Human Rights, the United Nations Charter, Article 51C. I apologize. The United Nations Charter, Article 55C. The United States Supreme Court, Acts of State, the Foreign Sovereign Immunities Act 28, USC 1601, etc., the Convention on International Road Traffic, Day 19, September 1949, the World Court Decisions, The Hague, the Netherlands, Day 21, January 1958 AD, 1378 MC, and Executive Order 1310-7, United States Republic, North America, the implementation of human rights treaties, the National Constitution for the Continental United States, Article 3, Section 2, Amendment 5, Liberty Clause, Amendment 9, Continental United States, etc., etc. It goes on. I hereby demand a dismissal of any and all constitutional sanctions, claims, or other warrants or charges made or issued, which are devoid of true identity personages, a denial of the due process of a trial by jury of our own national peers, or absent of a verified and lawful indictment sanctioned by an assembled grand jury, and that we be availed all lawful constitutional secured safeguards established by the supreme law, with documented proper jurisdiction, venue confirmed in place. Wherefore, all parties of interest are authorized by this writ, pursuant to national and international law, to honor all substantive rights and constitutional immunities reserved for and to this and all Aboriginal, Indigenous, free and sovereign Moors, MERS. All officials are to enlist all available and appropriate measures to ensure that all Moors' substantive rights and constitutionally secured rights and immunities are not violated, not breached, nor abridged. The sovereign natural beings, the Moors of Northwest Amexem, being North Amexem, South Amexem, Central Amexem, and all adjoining islands, being here, is not to be arrested nor held for detention under any colorable circumstances. You are to notify the active ministers of the Aboriginal, Indigenous, Moorish nationals of the territory, organic land, the natural person named with appellations titles Ali, Al, Day, Bay, and El are all non-obligatory and thus exempt from customs, tariffs, taxation, owner and fee permit deception constructs, and from any other hindrance or restriction of his or her freedoms, allowed properties, compensations, rights of travel, or freedom of movement on, in, or within any member or non-member states of the United States Union, etc. The Moors, MERS, bearer of all the indigenous people documents, or any other indigenous people's documents, or without, is to be treated with all due respect and due process rights under the law. All available and appropriate measures are taken to prevent injustice, harm, false arrest, trumped up charges, or attack on the natural beings, persons, property, personality, conveyances, freedom, and or dignity. Explicit reservation and use of all rights reserved without prejudice. UCC 1 through 127, 308 UCC 1 through 103 is noted to all federal, state, city, and municipal peace officers in harmony with state statutes, and indicates the reservation of our rights, whereby we may reserve our substantive rights and constitutional rights, secured rights, and immunities to not be compelled to perform under any contracts or agreements that we have not entered into knowingly, voluntarily, willingly, or unintentionally. We do not accept any actual implied liabilities associated with any compelled benefits of any unrevealed or deceptively imposed commercial contracts. We furthermore do not sanction any unconstitutional rules or policies or acts of misprision committed by any U.S. government or state officials at any level claimed by any of them in the name of the United States Republic, nor do I assent to any implied, and nor do we assent to any implied colorable policies made by alleged representatives as being sanctioned by the people and citizens. Consider any formally assumed constructs alleged to be related to us as being misrepresentations and thusly cured forthwith. Let it be known. Represent means to depict or portray, to symbolize, and to stand for. Let it be known that the United States Society Bar Association lawyers, esquires, and attorneys of European colonial descent and foreign corporation cannot depict, portray, or stylize a free Moor, as they are not of the same nation, jurisdiction, customs, or national peers, and cannot sit in judgment of any free Moor acts of state. Europeans are not indigenous to the land, Americas. Moors are aboriginal. United States lawyers and attorneys operate in demo political format, which is contrary to Article 4, Section 4 of the Constitution for the United States. Moors operate in a republican form of government, conjoined with Islamic principles, being in harmony with the Constitution. Moors respect Constitution principles. The unconstitutional tribunals operating under the Union State Society conflicts with and is repugnant to due process under Constitution principles and functions primarily in colorable procedures. Therefore, no fair, just trial or remedy is available to the natural peoples of the land through such colorable process. These violating acts constitute a conflict of interest, a conflict of law, and clearly establish the federal question of diversity of citizenship, a conflict of identity, and of nationality and international law, etc. Thus, a clear documented averment of jurisdiction, warrantro, is also hereby proclaimed and advanced to all parties of interest. Only Moors can present Moors and depict themselves as being Moors, all Moroccans and Aboriginal indigenes of the land. Thus, only Moors can present self. We are Moors, I being Sultan Noble Victor Royce Duquesne, being a real, live flesh and blood, breathing divine and natural being, born sanguineous, of the natural, thinking, animated mother, do solemnly, sincerely, and squarely affirm that the foregoing facts contained in this constructive and actual judicial notice and proclamation by a firm affidavit are true. This notice is constructed to the best of our knowledge, conjoined to our culture, customs, and beliefs, being actual, factual, and restorative in the nature to our ancient traditions and customs, presented as correct and not misleading, etc. Being the truth, the whole truth, and nothing but the truth, as with our ancient traditions and custom, we entreat all to love, truth, peace, freedom, and justice. All rights reserved without prejudice. We are Moors. We're living. We're still here. We are the beneficiaries of our estate, of our ancient foremothers and forefathers. We are not dead people. I am Sultan Noble Victor Royce DKL. We are Moors. North America, South America, Central America, all surrounding islands, known as North Amexem, South Amexem, Central Amexem, and all surrounding Americana islands. Peace and love. We are the Aboriginal, Indigenous, free, sovereign Moors, natural peoples of the lands, and propria persona, not pro se, not colorable, non-combatant. We are peaceful people. Peace and love. Paz y amor.